Good morning to one and all. Welcome to Legal Matters by Sai Baba Sankara. In this video, we are going to discuss the Supreme Court decision on the reversal of conviction in a murder case. The grounds are clearly explained and they will be useful for the police officers. If any police officer, if he sees, please observe as to how the court can find fault with your investigation on simple matters. Normally, this video will be of much help to the police officers than the advocates. Of course, advocates already, they know. Right. Coming to the case, Supreme Court reverses the conviction given by the trial court and also the High Court, holding that the investigating officer did not follow the procedure envisaged in Chapter 12 of the CRPC. You may be knowing, Chapter 12 of the CRPC deals with the information to the police and reaction. That is right from section 154 to 176. This comes under Chapter 12. 154, yes, correct. Information to the police and their powers to investigation, like that. So he has not obliged to follow the procedure envisaged in the particular chapter. This is the remark against the investigating officer. So, two judges bench, Honorable Justice B.R. Gawai and Sanjay Karol, in the case of Maghavendra Pratap Singh alias Pankaj Singh versus State of Chattisgarh in Civil Appeal number 915 by 2016 on 24/4/2023, latest edition, held that the IO did not meet the obligations cast upon him under Chapter 12 of the CRPC. So there are lot of infirmities and which affected the conduct of the IO in collecting the evidence. So the perfunctory investigation, now it is leading to the acquittal of the so-called appellant. These are the observations made by the Honorable Supreme Court of India. Now coming to the factual background of the case, it's not an easy case. Here, please remember, a businessman by name Govardhan Agarwal. He was shot dead by two motorcyclists in Chattisgarh on 26/9/2009, and it created a sensation. And actually, of course, even though he was taken to the hospital, he died, he declared dead. Ultimately, a case of 302, 201, then the so-called section 25 of the Arms Act, all these sections were booked against some persons. And on the particular night, information came against the appellant and two others. Ultimately, some 8 persons were arraigned as accused in this particular case. Charge sheet was filed against 8 persons. Right. Now, the trial court, I think the trial court acquitted only one accused and convicted the other 7 to life imprisonment, basing on the circumstantial evidence available. So the court is satisfied that they have committed the murder. Okay, conviction was given and one acquittal. Matter was appealed to the High Court. In the High Court, only this appellant was convicted and all others are acquitted. Now the appellant came to the Supreme Court in the shape of appeal. Now, Supreme Court analyzed the prosecution case threadbare. They have, of course, you may be knowing, they will analyze the case by the documentary evidence only. So, they know that it is based on circumstantial evidence, previous conduct, last conduct, Section 8 of the Indian Evidence Act, all these things they have discussed. But came to the conclusion, even the High Court also did not apply its mind properly. So, High Court, they have commented on the High Court also. But anyway, now coming to the Supreme Court's observations, very critical observations against the IO. Before that, they have noted that the prosecution's case is based on circumstantial evidence and the two independent witnesses, they turned hostile and they stated that their signatures was taken, they were threatened, their signatures were taken on blank paper. That means they must be the mediators. And the victim's son, I think nephew of the deceased, he did not point fingers towards the so-called appellant and others. Therefore, they held that IO failed in the following points. So, police officers, get ready. The lapses in the investigation. Number one, the IO did not examine the owner of the house of recovery. Whenever you make any recovery, you have to invariably examine the neighbors or at least the owner of the house, which was not done. Number two, did not enter the movement in the CD. Did not enter the movement in the CD. If you refer to section 172 of the CRPC regarding the case diary, it will be clearly written that when did you start investigation. I will read out the provision, section 172. 172. Diary of the proceedings of the investigation. Every police officer making an investigation under the chapter shall day by day enter his proceedings. So, setting forth the time at which the information reached him. Number one, the time at which he began the investigation, the place or places visited by him, and a statement of the circumstances and the statements of the witnesses recorded. They can be appended in the part 2. So likewise, the movement should be noted. It was not noted. Then, no record to say that the IO took the accused to recovery. So, there should be some evidence. That means general diary entry should be there. After interrogation or after confirmation, he stated like this, then we are proceeding to the place of recovery. No entry was made except the CD. Next, fourth point, not able to place when the recovery was done. So, what is the exact location of the place where the recovery was done? This is more important. You will be subjected, the IO and the witnesses, they will be subjected to cross-examination. Suppose if you say that the recovery was taken place near some topu. Where is that topu? On which corner of that topu? And which place? You have to be able to specifically say, otherwise this problem will come. Then, next point, such punch witnesses do not belong to the area. Once again, section 100. So, whenever you conduct the search, whenever you arrest a person, you have to take the assistance of the local persons. That's why two respectable inhabitants of the locality. So, these people belong to other area. That means, sixth point, no locals were taken in conducting the search. Right. Next point, the memo of arrest and the recovery were not prepared by the IO. Of course, normally the IO says that I have entrusted the work to the Maraitha, but it is containing so many mistakes, many corrections. Even the Mahazar or Panch mediator nama, it contained more overwritings. And the IO stated that he did not prepare the arrest memo. It is a clear violation of D.K. Basu versus State of West Bengal 1996. Is it not? So, last point. Not clear about the description of recovered articles. Even they could not write the clear details of the recovered articles. So, and therefore, basing on the lacunae in the investigation, that means saying that the investigating officer did not perform the investigation as per chapter 12 of the CRPC, the scene is reversed. The conviction given to the appellant is reversed and the case ended in acquittal. So, it is also proved that there is no controversy. So, definitely the conviction given to this particular person is reversed and he is acquitted. Very beautiful case law which will be a gain to the leading defense advocates. And it is a very classic lesson to the investigating officers what to do and what not to do. Please follow section 161, section 172, section 173 and they have discussed section 100 also. Alright, please once again refresh your memory. Lawyers, please read the case law and definitely you will get enriched with the legal knowledge. With this, I am concluding. Thank you very much.